Well, we come to question 5, which Deputy Mezek will ask of the Attorney General. Deputy.
Thank you, sir. Given that the Viscount's Department have now stated that the media were provided with information in the bankruptcy case of the former Deputies Pitman on the condition that it was confidential and could not be broadcast or published, what action, if any, is the Viscount able to take as those conditions were broken?
Solicitor General.
Yeah, thank you, sir. Bankruptcy is a process that involves the Royal Court. If parties involved in an ongoing legal process are unable to resolve their differences, then it may be that the Royal Court will be invited to do so. Such matters are for the parties, possibly the Court, but with respect, this is not an appropriate subject for political debate in the States Assembly. I decline to make any further comment on the facts of a particular case.
So I'm trying to keep my questions as far away from the facts of the case, simply use it to illustrate as an example. Would the Solicitor General consider the publication of personal information, including income tax details, to be a breach of the Article 8 under the ECHR right to privacy? And if that is the case, what recourse would a wrong party have under Jersey law in that occasion?
The reality of this question is I'm being asked to comment on a particular case, and I decline to do so. So, can I ask a point of order? If the question's been ruled in order, sir, then surely an answer should be forthcoming to a question which is in order.
It is always open to a person who is the subject of the question to decline to answer. What consequences flow from that, flow from that. Deputy Higgins.
Thank you, sir. In fact, I wonder why the Solicitor General even bothers coming to the Assembly if he won't answer questions. However, can I ask him, and this is a question general, not about this particular case, can I ask what protocols or what documents there are that lay down the procedures on what should be done? And if there aren't any, when will they produce them?
I don't understand the question. I don't know what protocols are being referred to or who is supposed to be producing them.
I'll try and explain further, sir. If data... we have a case where data is being given out. What I would like to know is, what rules are there from the Viscount's office for giving out data, personal data, and what data, or any data for that matter, what are the rules regarding the disclosure of data? Are they written down? Are they available for everybody to see? And if so, where are they?
Yes, so the question just began. We have a case where information was given out. So again, I'm just being asked about a particular case.
With respect, sir, I'm asking a general question. I'd like to know, have you published anything, has the Viscount's office published anything, and where is it? Because if it doesn't exist, you may definitely go wrong.
I think that last part was unnecessary, Deputy, if I may say so, but the question was a general one, Solicitor General. As it's not your department, you may not know the answer to it, but the question was a general one. What protocols, if any, are available through the Viscount's department for the publication of data?
So I don't know off the top of my head. All I will say is the Viscount is, of course, accountable to the Royal Court.
Yes. Deputy Tadier?
Thank you, sir. Again, as a general principle, could the Solicitor General answer why one would give out information that is confidential to a third party, in this case perhaps a media entity, on the condition that they cannot use that for broadcasting and disseminating?
Well, I'm not sure, Deputy, in the light of the previous answers, that you can say it's a general question when you say, in this case, the media, but still.
Okay, so let's try again, shall we? Is it normal practice for confidential information to be given to third parties if they agree not to use it?
Well, that all depends on the facts of the case.
Final supplementary?
Thank you, sir. I have the wording for my first supplementary question written in front of me, and it didn't specifically refer to any case. I think the Solicitor General decided he wasn't going to answer it before I asked it. So let's talk hypothetically. If there were a situation where the Viscount gave the media access to details explaining it was public interest disclosure, and then 1 month later wrote and said, actually, the information was meant to be confidential, not for public disclosure, what recourse do members of the public have when they're messed about by State's departments like this?
Standing orders actually prohibit the asking of hypothetical questions.